Good evening, viewers. Welcome to episode 48 of COVIDCASTJA Business. Today, we are continuing our discussion, the willpower discussion, because you have to have willpower. Today, we'll be continuing with part 2 of planning your estate. We want to thank our sponsors, the National Commercial Bank Group, NCB Group, and the JMMB Group. COVIDcast, we are here every Wednesday. Every Wednesday? Did I say every Wednesday? Every Thursday. Hello, Sandra. Every Thursday at 7:30 p.m. If this is the first time for you joining COVIDCASTJA, please visit us at smallbusinessportal.com. You can catch up on all our 47 other episodes, but you'll also be able to get access to the memos that have been created especially for you or micro, small, medium enterprises as you journey through business. Stay informed with us at the PSOJ. Email us at sme@psoj.org to join our mailing list for the weekly memo. This week, we did not publish a memo because we are at part 2 of willpower. So please just refer to the SME memo that we sent last week. But we're continuing our discussion. There were some great questions that were asked last week. I see Sandra, I see Trudes. Hi, Trudes. Welcome to the show. Please get your questions ready because we are going to be joined today by 2 ladies. One, Camille Facey. I'm going to introduce them shortly. And Sophia Dawkins, who is the SME Relationship Manager at JMMB. Now, tonight is very important. We went through the checklist last week of creating your will and some considerations. Camille Facey is going to get into what we did say the nitty gritty so that we can really have a conversation about estate planning. Now, for those of you who joined us on our Let's Go Digital journey, we've been getting that question, where can I find the information? How am I going to get to rewatch this amazing conference? And an amazing conference it was. We had over 1,200 participants for our March 5th conference, March 5th and 6th. And the conference is available on our YouTube page, and we're going to post it in the comments shortly so that you can get that information and have access to it. Now, we're celebrating just over 1 year of COVIDCASTJA. I needed to have brought my streamers out. Yes, we've been at this with our MSMEs, and we will continue working with you as we go through COVID. I hope everyone had a safe and blessed Easter. Get your pens and papers out because it's business time. This is the business of you planning your estate. Now, we are going to be joined by a young lady, Camille Facey, an esteemed attorney at law and managing partner of Facey Law. Now, she has been practicing for over 37 years, so don't let her youthful looks throw you off. So this is over 37 years of legal experience, which she uses to her advantage and the advantage of her clients as a current managing partner of Facey Law. Her practice is focused in areas of company and commercial law, corporate governance, telecommunications, banking, conveyancing, trust, and estates. However, prior to Facey Law, Camille spent 10 years as a senior vice president and later as a regional vice president with responsibility for legal, regulatory, and public policy in Jamaica and the Northern Caribbean at Cable and Wireless Flow. In addition to her legal expertise, Camille's world-class business acumen and leadership skills in creating and developing and leading highly effective and engaged professional teams resulted in her receiving awards for excellence, such as the Cable and Wireless Global Summit Award for Excellence in Legal and Regulatory. Now, one of the things, if you know Camille well, Camille knows how to break down the most complex issues in a manner that you actually feel that you're a lawyer after. Camille, welcome, welcome, welcome. I've seen Yolando Minot Sutherland joining us, Max North, welcome, Jana Patterson, welcome all. We now have Camille Facey, managing partner of Facey Law. Camille, last week, welcome Camille.
Hi Rochelle, I'm so glad to be with you. Good to see you.
Yeah, some people may be wondering if your face looks familiar. So, Camille is one of our expert advisors on COVIDcast. Yes, yes. So we are glad to have her back, and she always jumps on board to assist us with any legal issues. So last week, Camille, we went through some of the checklist items as we are preparing our wills. So when we noted the questions that were being asked by our viewers, we said, you know what, we need to continue this conversation, and who best to continue the conversation with than Camille Facey. Now, Camille, one of the things that people ask is, you know, I don't have a lot of things to will out to nobody, to will to nobody. Is there a difference, Camille, with just simply crafting a will, so drafting your will, and estate planning? Are they one and the same?
They are aligned, but there is a difference. So as you were alluding to, if you're going to plan an estate, the first thing you have to have is the estate, right? So what is an estate? The estate would be your house, your shares, your money, your investments. All these things constitute your estate. Now, when you make a will, you say, all right, I want to leave my house to my daughter, I want to leave my car to my son, etc., etc. And sometimes people go through and they will everything to who they want to get it. Estate planning now takes you that step further. It not just tells you who gets what, which is what the will tells you, but it tells you how they're going to get it, how the will is going to be administered. So let me give you an example. Say you have a house, and that's what you have, a house, and you leave your house to your one son or your one daughter. Now, in order to get that house, that will that you have said that Rochelle Cameron must get the house has to be probated, which means you have to get a lawyer. You have to go to the Supreme Court to get it probated. That costs money. And then you have to pay a thing called transfer tax on death, which is 1.5% of the value. So by time you, and that's much less now than it used to be in the past. In the past, it went all the way up to 15%, which is why you had a whole heap of property out there where the beneficiaries couldn't afford to probate their estates. So even though the thing may have been willed to them, they never actually got it because the estate, the planning that was necessary to see where would the money come from to pay for all of this so that my beneficiary could actually get it, that planning wasn't done.
Okay.
Now, let me go a little more rush, because that estate planning, you know, can go to a degree where you have what you call a nil estate. Because you could decide, rather than leaving that house in my will, I'm going to put my son's name on the title so that it is joint. So when I die, the property goes to him, quote unquote, automatically. Meaning you don't have to probate any will. What you do is you take the death certificate and you do an application to note death, which is a much cheaper and simpler process. It's like a bank account. If you don't put anybody, you could put somebody's name on the account. And then in that case, then that person can just go in and automatically draw the money. If you will that bank account to somebody, you're going to have to get the probate. So that is what estate planning is about. It's going through and determining how that estate will actually get to the people who you want it to get to.
Yes, thank you for that, Camille. Because I know that last week, last time we met, some of the questions that were being asked, you know, do I have to leave everything in my will? Which is why we're having this further discussion about estate planning, because you can actually plan how you will dispose of your estate, and some of these things don't have to be disposed of through the will process. You can actually do that before. So, Camille, public business owners, though, because sometimes that's where we get into some, we cross the line between what is owned by us, so what is owned by Rochelle and what is owned by the company, of which is you're probably even the 100% shareholder. Now, for business owners, what are some of the key considerations that business owners need to be making as they're doing their estate planning?
Okay. So once the company owns an asset, you have to remember that it doesn't belong to you individually. That company is a separate legal person. So that office building or that equipment is owned by company limited. What you as the individual own, you own the shares in the company. So you can't make a will and say that I give the company property to my wife, or I give the equipment to my stepson. Or what you can will at that point in time would be the shares in the company. If you have a company, you have to really seriously consider continuity after you are gone, succession after you are gone, because many times you are that company. So that company may not exist after you go. And always remember, with estate planning, it's very unique. It's unique to you. It's unique to your circumstances. It's unique to your particular situation. So say you have a company now where you have a partner, and you think that after you go, that partner would keep that business going, the business is well capitalized and it would grow, you could decide to leave your shares in that company to your child, because you think that that company would go on and eventually would pay dividends, and you would trust that your partner wouldn't take all the money out of the company in management fees, but would leave something to be able to pay dividends to shareholders. So you would, in your will, leave those shares to your whoever you want to get them. If, however, you were a one-man company, nobody else could run it, then you should probably have a plan that if something happens to me, we're going to liquidate this company. And remember, on a liquidation.
Hold on, Camille, when you say liquidation, what do you mean by that? Turn it into water?
Wine it up. Yeah, man, kind of like that. Wine it up. In other words, cause it to stop running.
Yes.
But no, the same way you went through a process to incorporate it, to set it up, there's the same way there is a process to wind it up. And there are some things that have to be paid first, like employees would have to be paid first, taxes would have to be paid first, any creditors would have to be paid first. And then it would only be at that end point now where you have an excess of assets over liabilities, that those assets now could then be sold and the shareholders would get what remains. Okay. So I'm saying all this to say that you have to look at your particular circumstances when you are planning your estate, because the plan has to be about your assets and about your circumstances.
So Camille, I know some of our small business owners are listening and they're saying, I hear what Camille's saying, but here we know we're going through COVID, and I'm just trying to cut and go through. So when you're talking about estate planning, where I must find time for estate planning? Why is this important? And I see Stephanie Patterson. Hi, Stephanie. Stephanie says, not much discussion is had about wills or estate planning for that matter. Very grateful for this discussion. Thank you very much for that comment, Stephanie. We have Camille Facey. So as Stephanie has pointed out, we don't have much discussion about it. So even as we are cutting and going through as business people, we're not thinking about an estate. We're just trying to get some revenue. We're looking at the bottom line. Why should we even be addressing our minds to this?
If you have anybody you are responsible for, if you have a child, if you have a parent, anybody that you would want to ensure that if something happened to you whatever you had would be available to assist that person, then you have to think about it. And this is why, and we're not just talking about making the will. We're talking about what are the other ways of ensuring that what you have wouldn't get locked up in a bank and nobody else can get access to it, because the bank is not going to just go and give that money to somebody who comes and says, oh, she was my good friend. The bank is going to say, you show me the probate or you show me the letters of administration before you get access to 1 cent. So the fact is that once you have any asset at all, you want there to be a plan as to how it would be disposed of. Say you buy an insurance policy, you either name a beneficiary, where then that beneficiary, once they have the death certificate, they'll claim on the policy. But if you have put estate, then you better make sure you have made a will and say who is to benefit from that insurance policy.
Because I know a lot of times, with those insurance policies, we can't think about it at the time, and we're like, I'll get back to who that beneficiary is. And if there's no beneficiary, and you said estate, it is going into an estate that's either one that's governed by a will or one that you've died intestate and there is no will, and it have to go through Auditor General. So
Administrator General, yes, which you don't want. Yeah.
Yes. So Camille, when I've set up a company, and you touched on what happens with a company, so I'm going to get back to that. But if I've set up a business and I've just registered a business name, are the considerations for how I can dispose of things different than if I've set up a company?
Definitely. Because now, remember, the business name is not a limited liability company. It is Camille and Rochelle trading as Rushcam. So those assets in that trading name, they really are still in the name of Rochelle and Camille.
Yes.
So then you deal with it as you would deal with assets owned by an individual. Whereas a company is a legal person. Under the law, a company is a person. So that's why if the company owns something, you can't say it's yours. It belongs to the company. What you own are the shares. So it's two different situations. One is still a personal asset situation. The other one, where it's an incorporated entity, the assets belong to the company. And what you would have to will there would be the shares.
Yes. Okay. So when I have set up a company, you've mentioned shares. What assets can I actually dispose of? Because you talked about shares and things like equipment bought in the name of this limited liability company. How do I dispose of how do I address those things in my will? I just have to will the shares to somebody? How does that work?
Right. You know that you have, say the company has 200 shares, your partner has 100, you have 100, then what you will are those 100 shares to whoever your beneficiary is. The company will continue to own all the assets, meaning the car and the equipment, and that company will hopefully continue to run after you pass and continue to make money. And then the value of those shares will increase, and your beneficiaries will, once the will is probated, those shares will be transferred to their names, so they would replace you as the shareholders in that company. But if it's a small business at all, I think small business people should discuss with their partners how they would want things to be handled in the event of their demise. And sometimes these things are agreed beforehand and put in shareholders agreement, where their shareholders say, if something happens to me, this is what I would want to happen. And partner, are you agreeable to that? Will you make sure that you then run the business properly so my children one day can inherit? Or is it that this business would be closed down, the assets sold, and then they could get, what is left over after all the debts are paid?
Yes. So Camille, I really like how you made that particular point, because even, as we keep talking about that, people with estate planning, they say, oh, when I reach a certain age, may we plan the estate. When I have a certain amount of things, I'll start thinking about it. But even as you are coming together with partners for a business, and you do something like you say, everybody's gonna get there are three of us, and you split the shares evenly across the three of us, that a shareholders agreement, do you have a shareholders agreement that speaks to how each of you will dispose of your property upon death? Because it can affect what could be a very successful, that started as a little teeny weeny business, that now you pass away and this is a massive profitable business that can easily fall apart because these things were not thought through.
Yeah. And Rush, just to vary a little bit, I always, a shareholders agreement is something that I think is so important for small business people, because just like with a marriage, I call it the prenup, because it's always good at the start to sit down and say, all right, we love each other today, but if next year we don't love each other so much and we want to separate, this is how we're going to separate. Because of course, when you're not getting along, that is when you can't agree anything. So you agree these things at the start, that, if certain things went wrong, this is how we would separate. And so one of those things could be, in the event of death, because your partner might say to you, look, I trust you. In the event of your death, I want to buy out your shareholdings and give your beneficiaries the money. And that would probably suit your beneficiaries, because especially if you have children, you could put that money down and, they get the income from that to pay the living expenses until they get old enough to get the capital. So as I said, each thing is particular to your circumstances, and you have to, work out what works for you.
And Camille, I'm seeing a question here from Trudes there. Thanks for this question, Trudes. And she's asking, in the case of a trading ads, if the principal dies, how can family members collect amounts outstanding?
Okay, so trading as, and we said Trudes. Trading as, that was from Trudes?
Yes.
All right, so it's trading as Trudes and Associates. Now, when you say things outstanding, if it is a bank account, right, so the bank owes you money, the money is going to be in the name of Trudes trading as Trudes and Associates. So the bank is not going to allow anybody but the administrator or executor of Trudes to get that money. If it is that people owed Trudes and Associates money, then how would the people who owe the money know that they're paying it to the right person? They're going to want to see the probate or letters of administration if there was no will, because it's not as if Trudes and Associates is a separate legal entity. It's not a company. So you can't, if the company, remember, has perpetual succession. It lives after you have died. That doesn't apply with a trading as situation.
So, and I think that was such an important question, because we've discussed previously on this show, and Camille, you have actually discussed with us whether we should move from business name to company, and some of the pros and cons of actually registering a business, and what happens when you registered a business versus you formed a company. And it is something that you consider, and you need to consider too, as your business grows. Is it time for it to become a limited liability company? And where it is, and there are a lot of profitable businesses that are still trading as. What happens with your family members upon your death? Because with a company, the company can continue. It's perpetual succession. I see Jana asking, is that the case for partnerships as well? Camille, can you touch on partnerships?
Sure. Partnerships are not registered. Well, we are now we have legislation being passed that's going to deal with that. So I'm not able to speak fully about that tomorrow. But today, because I don't think the legislation is yet in force, a partnership would fall in the trading as category, where it's still two individuals who have got a partnership deed, and they have the assets would be owned by those two people. Right? So at least with a partnership, the other one should be able to deal with the assets. But let's think about what assets we're talking about, because if it's equipment, usually it's not in a name. That's something you can pick up and hand to somebody. But if it's a car, the car would be registered in the name of the person. So if it's in the name of the person who died, then you're still going to have the same problem with getting the probate or letters of administration. If it's real estate, the real estate now going to be in the names of the partner, you're going to be in the names of the two people. So then how was it held, as joint tenants or tenants in common? Right.
And so you're here and we're picking on your advice now, because we're so happy to have you on COVIDcast. You've mentioned this concept of joint tenants versus tenants in common. And I think it's just something that it's important for us to point out the differences as you are disposing of your property and planning your estate.
That's what I was going to say. That is estate planning in and of itself.
Yes.
Because when you are buying a property, if there are two of you going on the title and you put it as joint tenants, it means that that property will go, quote unquote, automatically to the other person. Nobody can intervene. That other person going to get it. All they need to do is, it's a thing called making an application to note death. You say you still have to go to a little lawyer, but it's not so expensive, and you produce a death certificate. You don't have to go and get probate of the estate, and the tax liability will be less because it's only a half share that it's moving. And if it's a matrimonial home, then the taxes are much, much reduced, almost none. Whereas now, or the family home, I shouldn't say matrimonial home. Whereas now, when you own something as tenants in common, it means that each of you has a half share in that property, or if it's three of you, 1/3 share, or however many, which you have to will. And therefore, it won't go automatically to the others. And I cannot tell you how many clients I've had. I'm just completing one now, where it was owned by 4 people. One died from the 60s. And then as soon as the executor was about to deal with her estate, he died. So by the time they came to me, I had to go through about 3 or 4 different estates in order for the remaining persons to finally be able to get to deal with that property. So there are 2 things: joint tenancy or tenancy in common. With tenancy in common, you have to make a will, and then your estate will have to be probated in order for whoever you named in that will as your beneficiary to get that share of the property. If it's a joint tenancy, it goes automatically to the other person who is joint with you on the title. So that's one of the things you can do when you are planning the estate. If you know for sure that this is who I want to get this estate, you can put that person on as a joint tenant. Of course, we have to bear in mind that maybe later on we might change our mind. So that's the downside.
Yes.
Right? So you really have to think about how you want to proceed.
Okay. So Camille, if the asset, so for example, I've bought a building in the name of the company. So the building is actually owned by the company. As this estate is being planned, and you're even thinking about beneficiaries and all of that upon your passing, this building that's in the name of the company, how do you leave that building to your beneficiaries?
Okay, I don't think I've been talking so clear. You cannot leave the building to your beneficiaries. You have to leave the shares to your beneficiaries. Because remember now, the company owns that building.
And it's a point that we have to keep making.
Yes.
Because sometimes we forget, and that's why I keep asking this question to ensure that we are getting the point. that it is the shares in the business that we can actually leave to people. So when the building is in the company name and the car is in the company name and the piece of land is by in the company name, you can't pass it out and say Truth's going to get peace and John are going to get peace.
Correct, Rochelle.
Is the shares.
Is the shares. And that's not a bad thing, because remember now, the whole point of, think if we were talking about a big company like Grace Kennedy. It's the shareholders of Grace Kennedy, and those change all the while. But Grace Kennedy continues to own its buildings and continues to have all its assets. And then the shareholders, what we have now are little pieces of that company that we can trade. So it's the same thing with our little companies. We have, which are going to grow big, we have the assets owned by the company, and then now the shares, we can have 5 of us who are shareholders. Exactly. So if something happened to me, that company could still continue, and my shares could be there growing, and I could leave them to my children, or the other shareholders could have agreed with me that if something happened to me, they would want to buy out my shares and let my children have the cash. So that, so each situation is unique. And each company is unique. And
Camille, you have been making that point just constantly, the difference between when the assets are owned by you as an individual versus the company. So the company owns the assets. Because when the company owns it, they're not owned by you directly. You own the shares of the company. And sometimes we don't think of ourselves in the same way as a large business, but we are treated the same way when we formed a company. And not that it's a bad thing, but we have to ensure that we know how we will dispose of assets in these different circumstances. I love Truth, a senior here. Truth said, if someone makes a will, Camille, prior to marriage, is that will effective if the party dies in marriage? Make we ask that part there first, because I think it's a 2-part question. Thank you for this, Truth. So if someone makes a will prior to marriage, is that will effective if the party dies in marriage?
So I hope it's not the marriage that caused the death. But once you get married, then that will is now invalidated. You have to make a new will. Right?
So the will that you made when you were unmarried or not married to that person, when you get married to them, that will is negative, is done. Right. So you have to make a new will.
Unless you made the will in contemplation of marriage. But normally, it's invalidated. Then no. What if you are in a common law relationship, living together for over 7 years, and have made a will before the start of the relationship and dies after 8 years in that relationship? Is that will effective? No. Listen to me. A common law relationship, living together for over 7 years, so you are treated as a spouse. So you are now treated under Jamaican law as a spouse, and you have made a will before the start of the relationship.
Yes, and you die after 8 years in that relationship. Is that will effective? So in other words, you were together for 7 years. You had a will. You are now considered a common law spouse. When you get married to the common law spouse and you're no longer common law, but you're capital law spouse, is that previous will negatived?
Right. Okay. They didn't say they got married. Okay. So once you get married.
You make that part there up. Sorry.
Yeah.
And dies after 8 years in that relationship. Truths, were you asking if they got married after? Because if they die, if they were living together for over 7 years, made a will before the start of the relationship, and the person dies at year 8, your will is still in effect.
Yeah, I suppose what she's asking is whether or not the legal situation that you're now treated as a spouse negatives that will. I don't think so, But I would have to do more research on that, but I don't think so.
No, I don't think so.
Yeah.
I think I had actually looked that up on behalf of a client, but what happened is they got married after. So it's not negative. But you know what? Let's double check. And see really how is that addressed. Thank you for those questions, Truth. Please, viewers, send in these questions. She says that's the question, Mrs. Facey.
Yes. No, I think that will should still be valid. But we'd have to check to see whether the Rights of Spouses Act would negative the will. I think what it would do is, like, say if it's property, it would say that that spouse, that common law spouse, would have certain entitlements to the property, you know, a certain percentage. So that is, I think that act would probably affect it. But we need to do a little more research on that.
Yeah. Thanks a lot for those questions, Trudes. So Camille, what is a trust?
Okay. So a trust is a legal vehicle which allows you to take assets, whether it's money or real estate or shares, and say to your trustees, hold this from a beneficiary. So the usual situation would be a child. So Rush, you have Christian, and you make a will, and he's a baby, and you want your assets to go to Christian. So you would say, I give, devise, and bequeath my house, my houses, and my Rolls Royce, and all my great assets.
Things, all for money. Thank you.
All for money. To Camille on trust for my son on his attaining the age of 18 years. And what I would have to do as your trustee is I would have to take care of all of those things and make sure now under the law and under your will, you would give me power to use those assets for your child during his minority. Or say it's your mother that you wanted to take care of in this way. And I would then be able to say, sell if I needed to, some real estate, and then use the money to pay medical expenses or pay school fees. So the whole concept of a trust is where there are the people who you want to benefit, but you don't want them to get the assets outright. So you give it to people who you trust to manage them until a certain point in time. Or it may be, say it was to your mom, on trust to my mother for life and on her death to my child. Okay, so very often you find trusts that are set up in wills, but a trust can also be a freestanding trust.
Yes.
You could just decide today, as I said, all of that, you know, you win the lotto and you decide to take some money and put it in a separate trust because you want to benefit a particular organization. Say you wanted to benefit and trust, you know, with the income to go to Cancer Society or whatever. Or there's some people who set up trusts for children. They just take a certain portion of their funds and they give it to trustees, and they say that they, even during their life, they've done this. That, you know, the child is to get the income from the trust until they are turned 30 or 21 or whatever age you decide.
Yeah. And that is a situation where you're still alive,
yes.
That person. So, and I think that's one of the key things to understand with a trust, that a trust can be created and actually come to fruition in your lifetime. So it's not dependent on your death. I see Yandi Yaya. Hey, Yandi Yaya says, interesting indeed. Every time we have these conversations about willpower and planning your estate, interesting indeed. So, what are some of the mistakes that you have found in your practice that people have in fact made in estate planning?
Okay, I think one of the most important things is to choose the right executors. You need people who know what they are doing, especially if you have a complicated, or even if they say it is not complicated. And you need people who you can trust, because you are allowing them to stand in your shoes. And they are going to now take care of your assets and ensure that the people that you want to get your assets get your assets. And the last thing you want to do is to put your beneficiaries in a situation where they have to be suing executors or suing trustees because they didn't get what they were supposed to get, because they were robbed. So you want people who you can really trust. You also want to ensure that you think through the situation, because going back to that house, if it is that you wanted that person to get the house and for the house not to be sold, but then to get the house intact, you have to make sure that there is enough money that's going to meet all the expenses. So those expenses would be the executor's fees, which are normally 6% of the value of the estate. The transfer tax and legal fees, that's another 5%, because all of that money has to be there, which is why sometimes you get insurance, because then the insurance can fund the estate so that your beneficiary gets that asset intact, if that is what you wanted to do. Other than that, the executors would have to sell that asset and then give the beneficiaries the cash after the expenses have been paid.
And that's a very important point, but I want to go back to that point. But
Sure.
you mentioned executors' fees. Can you just a little bit more about that? Because I think a lot of persons aren't aware of this, the various fees associated with the disposal of their estate.
Right. So under the law entitles executors to a commission of 6%. If it's 2 executors, they're entitled to get 3% each. If it's 3 executors, then it all comes up to 6%.
So that's the value of the estate?
Total value of the estate. And this applies, Rush, whether it is letters of administration and it is being done by the Administrator General, they get the 6%, or whether it's a will where you have named your executors. Now, very often, if you name executors who are close to you, they decide not to take the fee.
Yeah.
But under the law, it is provided for.
Okay. And the other fees associated with your probate, one of the things that you mentioned is that, as we're planning how we will distribute the estate and who will get what, sometimes we forget that there are some fees. So there's executors fees. What other fees do we have to contend with?
You have transfer tax on death. Now, in 2019, I think it was, that went down. And I mean, that's really, I mentioned it before.
Yeah.
It's really good for Jamaica, because there was a time, I mean, you mentioned how long I've been practicing. I have to take it out of my resume. That thing went all the way up to 15%. And that is why, as I said earlier, you had people who got assets and they couldn't afford to administer their estates. Now it is 1.5% after $10 million. So anybody out there who is listening who had assets that weren't, and estates that weren't administered before, now is the time to deal with it. Next thing you know, the fees go raised back again. So it is a good time to deal. So you have the executors commission, you have transfer tax on death, you have legal fees. Legal fees range from about 3 to 4%. I think that's the usual range, which is why I said call it about 5%. So 5% plus the 6%. So that's 6 and 5 right there, 11%. Those are the main things. I don't think, I mean, you have the registration fee and all of that, but so you have that kind of cost. So of course, if it's a big estate, then that can be, a sizable sum of money. And then if it's an estate that's just asset rich and has no cash, so you have all of this real estate and all of these cars, but you don't have any money to meet those costs, then obviously things have to be sold in order to meet those costs. So if you gave your Lamborghini to your boyfriend and there is no money to pay all of these costs, the Lamborghini going to have to get sold and he not going to get that what you had wanted it to get.
Yolando, Minot Sutherland says, exactly, Mrs. Facey. Glad you highlighted how life insurance can help to pay your final expenses and so leave your assets intact for your beneficiaries. Taxes and fees can be over 10% of the value of the estate.
Yolanda, sell insurance.
Thank you for that, Yolanda. And I'm so glad that Yolanda has made this point, because we're actually going to be talking to Sophia Dawkins Coombs of JMMB of some of the other considerations with insurance, etc. But Camille, you've mentioned and you've put it so nicely for us tonight so that we can understand. Colleen Edwards says, what fees? Hello, Colleen Edwards. What fees are required if I transfer property to a sibling while I am alive? So transfer for love and affection.
Love and affection, yes. So you're going to still pay transfer tax. So transfer tax now, drop from 5% to 2%, but you're going to pay transfer tax on a half share. And stamp duty is now a flat $5,000. Remember, that used to be a percentage. So things have come down when it comes to doing property transactions. So Colleen, you're talking about the 2% transfer tax on the half share of the value, $5,000 in stamp duty, and then 0.5% in registration fees. And again, it's on the half value. So that is estate planning. You do the transfer while you are alive because you decide this is a sibling that I would want to get this asset. Hi, Colleen.
And Truth says, if someone dies without a will, leaving cash in the bank, and is the sole person on the accounts, what will happen to the cash? We're going to talk about that a little more too with Sophia. So, Camille, answer that now.
Sure. The cash, the bank is not just going to go and give it to you. You're going to have to come there with letters of administration if there was no will. You said without leaving a will, right? So you're going to have to go get letters of administration, and you're going to have to take that to the bank before they're going to give you 1 cent of that cash. Even if there is a child dying for hunger, no. The bank has to know that they're giving it to the authorized administrator of the estate of the deceased.
Yeah. And again, Camille, as you said, as we are planning our estates, and in our last episode, we talked about some of the decisions that you have to make and the things that you have to consider if you are, for example, going into major surgery and there are going to be medical expenses to be paid. You're the only person on the account. Does anybody have any access to be able to assist with ensuring that these expenses? So you could have a whole lot of money in the bank, you're in a coma, and the things cannot be paid. So as we're planning, and as we're planning our businesses, I know we are focused on the bottom line, but we also have to keep our eyes open to the bigger picture of planning for how we will take care of our people. Truth say, mistress, too much charges and fees. And Truth, I'm glad you've made that point. Sometimes we get stressed out when we think of the charges and fees. Forget the charges and fees. That's why you get a Camille Facey to work that part out. But be aware of them so that you are planning for how they will be paid. So sometimes you need a little stress of knowing that there are charges. So as you're planning for that estate, you're putting things in place. Camille Facey, it's always a pleasure having you. How do our viewers find you? Because I know they need to know plan. Some plansig. Jana says she's laughing. She's with Truths. So when need to do this estate planning, to understand these fees a little bit more, and to have someone assist you with the estate planning, we have a Camille Facey. Camille, how people can find you?
So I am at Facey Law, which is in New Kingston on the Towers, but you can call us 876-920-1000. We're listed, or my email is cfacey@faceylaw.com.
Oh, thank you so much, Camille. And viewers, I know you're going to have to go back through this episode. It is going to be available right here on our Facebook page. It's also available on smallbusinessportal.com. Thank you very much for sharing with us today, Camille.
And Rochelle, thank you for doing the great job that you're doing for all our business people, big and small.
Big and small. Thank you so much. So, viewers, we talked about bank accounts, we talked about insurance. Some of you are wondering, really, what happens to my money in the bank? I need to have a conversation with a banker. So tonight we have Sophia Dawkins Coombs, who is the SME Relationship Manager for JMMB. Hello.
Hi,
How
hi.
are you?
I'm good, thank you. I'm good. Interested indeed.
Interesting indeed. I think that's what we're going to have to say.
Very interested.
Interesting. I see Sandra says very informative. Leslie says ask a question. This is not a question for Sophia though. What is the cost to place 2 children's name on a house title? Blessings. So Leslie and Camille had spoken earlier about the fees, the transfer fees for love and affection. So you can actually go back through the episode and get that information. But better yet, why don't you make an appointment to see Camille? Because I think this is something that you need to look into properly. So Sophia, what should MSMEs or business people consider regarding investments and specifically when it comes to their estate planning?
Thank you for that question, Camille. Very interesting. In terms of an SME, when we're thinking about investment and estate planning, as Camille just spoke, your estate is primarily your asset, right? And your asset is made up of your house, your car, your business, which is very, very important. And sometimes the business is really the most valuable asset in that estate. And so you want to ensure that you build that business, you invest in that business, and you ensure that it is secure, that at the end, if you are incapacitated or dead, then your estate, the business is able to continue. It has value, and of course, it has the proper structure too to continue operation. So in building that business as a part of your estate, you need to ensure, one, that the business is viable. You need to ensure also that in terms your plan is aligned with your financial plan for the business. In that, you ensure the business for most MSMEs, they are the CEO, they are the director, they are the secretary, they do everything for that business. And they need to ensure that they are planning for themselves and they're planning for the business. In that, they need to ensure they building the business where the cash flow is concerned, that in your budgeting, you budget for that investment that will ensure that the business can continue. What am I saying? You would not want to take, looking at your investment for that business, you would not want to take your cash flow and actually tie up in an investment that is not going to give you that maximum return that you desire for business.
So hold on a second. So Sophia, when you say you don't want to tie up your cash flow, what you're saying is that as you are planning how you will invest as a business person. So for example, what shares you will buy in other companies, that kind of thing. Is that what you mean? Or what investment instruments you use?
What investment you would invest in to maximize your returns? You may want you may want to invest in long-term assets, because estate planning has to do with your future assets, securing your future asset for your family and for yourself. And also in the event of your death or incapacitation, that your beneficiaries are able to.
I get it. So in other words, as a business person, as you are managing your cash flow and you're looking at the various investment instruments that are available, you have to be asking yourself some questions. What is necessary for long term? What do I need to be able to liquidate quickly in the event that I need to put back money into the business to grow the business? So these are some of the things I have to be thinking about as a business person, because sometimes I need a medium-term investment that will not tie up my cash flow too much, but that I will get a good gain on.
Right. You have to think about what will maximize your return to ensure that the business has that tangible network, that high network, that high value, that will ensure that you're able to leave that asset that's secure. You're securing your financial future for your family and for yourself. So in building that business and ensuring that business is secure, you want to ensure, one, that you insure the business, right? We spoke about ensuring that the business is protected. So you will insure the business. You will ensure that you have the necessary.
Sophia, when you insure the business, what do you mean? You are insuring the building that the business is in that you own, or what exactly should you be thinking of insuring, so that we kind of distill what we need to insure?
You can insure your stocks. The stocks. You can insure the assets of all the assets of the business. And also the key person in the business. So there's a key man insurance in the event, right? For the key person, yes, there's a key man insurance that if you passed away and you're not able to, there are some expenses and so on out there for the business, that insurance can take care of those expenses, and your business, your shares in the business can be, of course, passed over to your beneficiary.
Okay, so that's very important to consider. So, is there any other financial advice that you would give to our viewers for estate planning when they're looking just holistically at financial?
Right. At JMMB, we're a financial life goal center, and we take into consideration all aspects of our clients' financial needs, including our SME. Recently, our SME unit was launched over a year ago now, and what we did is ensure that we have the SME Resource Center. The SME Resource Center is actually a support unit for our SME clients. And what happened at the SME Resource Center? Your needs, most importantly, our clients are assessed and supported, and the needs are identified. Once we have identified your needs as an SME person, then you are channeled to the various units. We have our pension units, our investment units, our banking arm, and our insurance arm. So depending on what your financial needs based on your business life cycle and your goals, your financial goals, then you will be channeled to the various units. And also, in terms of the solutions that we have for our SME, MSME persons, we have a managed investment portfolio is ideal for our busy SME persons.
Okay.
With managed investment portfolio, you have our wealth builder, you can have your stocks, you can have your bonds, right? And also other solutions that we have for our investment, our MSME clients are the insurance, as we mentioned. Importantly is our retirement solution.
Okay.
Our SMEs are able to get their individual personalized pension plan from JMMB.
And that's the independent retirement schemes.
Independent retirement solution. So they can have it for themselves and also for their employees. It's an individual, independent retirement scheme.
So in other words, as a business person, there are varied solutions
for
and
our
different things to think about: the actual investments, insurance, your retirement solutions, because it's not just, we're not just thinking about when we pass on and we're passing on property, but also while we're living, after we reach a certain age, what is the retirement solution that is available to us as business people? That's another very important consideration.
Very, very important. And also the earnings on that investment. How is it that you invest as an MSME to ensure that you maximize the returns on your investment? A very interesting point I want to make, Rochelle, is when Camille mentioned about the fees, the various fees. So in your planning as an MSME, you want to ensure that you have your long-term, your short-term, and your medium-term goal. In your short-term goal, that is where you want to ensure that you have that liquidity to assist your beneficiaries when you pass, to ensure that they have those fees to cover the expenses that will be associated with transferring and, of course, moving the asset from the deceased to the beneficiary. So it's very, very important that in their planning, you have your short-term goal, as I said, which consists of your rainy day funding that will be able to enable your beneficiaries to cover those expenses. Of course, you want to ensure that when you pass, that they are comfortable and financially secure.
Okay, thank you very much for that, Sophia. So as we are wrapping up this segment, what would you like to leave our viewers with? What's that nugget you want to leave our viewers with?
I would like to say to our viewers that at JMMB, we are a family company. We are big on love and family. And so we take your financial life goal seriously, and we want to partner with you. We want you to come sit with us and have that financial plan, have that budget done, have that goal set. And of course, we will walk with you, we will work with you, and we will partner with you, holding your hands through accomplishing those financial goals by recommending the right financial solutions for you. And of course, JMMB have your best interests at heart.
Oh, thank you very much. Sophia Dawkins, SME Relationship Manager. She has almost 30 years of experience in the financial sector. I see lots going on in our chat. Trudes asks, what if you started a side hustle? It is generating revenue. How do you formalize this hustle? So Trudes, one of the things that we did on our previous show, we went into details with how do you formalize your business. So for example, you could look to register the business name. Remember, we mentioned it earlier in the show. So it would be like Trudes Dare trading as Trudes and Company. And that is one way of formalizing that hustle, registering as a business name. You may want to go that step further and register an actual company. So that company would be a separate person. That's a separate person from Trudes, where you have shares in the company, you have directors of the company, and that company can exist even when Trudes no longer is here. So that is those are two ways that you can formalize a side hustle. In fact, we're seeing a lot of persons since COVID formalizing the side hustle. It certainly helps you with your financial planning, because you are able to have access to opening accounts in the name of the business, and this business can enter into contracts, especially if you are in fact a company. So this is something that you want to consider doing seriously, and we strongly suggest that wherever possible you formalize your business. And Tracy Lee Long, thank you very much. Tracy says, hi, Leslie Johnson. Leslie, I hope you're still on, you know, because we get some good advice here from attorney at law, Tracy Lee Long. Tracy, could you also drop in our comment section where people can find you? So Tracy says, for transfer by gift, otherwise called a love and affection transfer, and Camille talked about that earlier, the general fees include transfer tax at 2% of the value of the interest being given to the children, stamp duty at $100, registration fee at $5,000, and attorney's fee. Bear in mind the ages of your children, as adding them to the title may potentially limit your ability to deal with the property if they are minors. And I know many of you want to get into further detail with Tracy about this transfer for love and affection. Tracy, again, if you can drop in the comments where persons can find you. Thank you very much for your assistance there. Today we spoke with attorney at law Camille Facey, and she got into some more detail with us, not just in the planning for your will and the drafting of your will, but this whole broader concept of estate planning. She went through with us some of the things that you can do in planning your estate. That planning your estate isn't just about making a will. You may, as Leslie asked about and Colleen Edwards asked about, can you transfer the property, a transfer of love and affection while you're still alive? So you add somebody name to the title, you may add them as a joint tenant. So if you pass away, the property goes to them directly and you do not have to, it does not become a part of your will. You want to consider things in your estate planning. Am I going to make this money available to my beneficiaries in a will? Or am I going to add them to the bank account that if I pass away, this person will immediately have access to the funds of the bank account? Do I put it in a will? Do I want to go as far as to create a trust for my children? A trust, I want to parcel out a particular amount of money and create a trust. You have to choose, asked about formalizing a side hustle. As you're formalizing a side hustle, remember that when you have formed a limited liability company and you've bought assets in the name of the company, that you're not able to just say, I'm going to give to John and Mary these assets of the company. You can transfer the shares of the company because that's what you own, the shares in the company. The company owns those assets. You have to be thinking about, if you're in partnerships, do you want to have that, as Camille put it, that prenup discussion with your partners before, how each of you will dispose of your property. You may have certain agreements. If it's a company, a shareholders agreement, that the partners of the shareholders may actually go through and say, you know what, if any of us pass, this is the process that we want to follow with how we will dispose of shares, that the shares will be made available to us to purchase and pay the money over to your beneficiaries. Remember, Camille says one of the big mistakes that we make is that we don't pick executors that we can trust. We have to have executors that we can trust that will actually probate our wills. We also have to remember the various fees that are associated with our probate and make sure that we have things in place. We had a comment in from one of Yolanda who mentioned insurance and gave us some more detail of insurance and how insurance can help to deal with some of the fees that you will have to pay. Remember, their executors are entitled to a fee. Executors are in fact entitled to a fee. There's transfer tax on death, there are legal fees. Everything amounts to probably about 10% so of the value of the estate. So these are things that we, as we're planning as business owners, as we're making these decisions on how we buy property, the name that property is being bought in, that this is a part of what we have to build into our thought process and our planning process, estate planning. Tracy says, thank you, Tracy. Tracy says a very informative session and even more informative with your input, Tracy. She can be contacted and see it. It's in the chat. Her number 893-3662, her email address, and she's on Instagram at Attorney Tracy Lee. So, ladies and gentlemen, you have been exposed to lots tonight as we have these discussions. Somebody said in the chat, interesting indeed, because as much as I know about this topic, the more you talk about it, the questions are very insightful questions. Truths really stretch us tonight with some very insightful questions. That these are things that we have to consider. We also strongly suggest that where you have these very important decisions to make, where you need to make a trust, etc., go and see a lawyer. Go and see a lawyer. So, ladies and gentlemen, this is part 2 of willpower. Your willpower, planning your estate. Thank you very much, Janice Thompson Carby and Yolanda. Thank you very much, viewers, for having joined us for episode 48. Many of you have been with us for this entire year. We will continue contributing to your business by providing you with insightful information. Please, we have some exciting episodes. We took a break last week so we could go back to the table, look at some of the new issues that have arisen that we need to be talking about with you. Do not miss an episode. For those of you who are joining us for the first time, that you said, what has been happening in my life? How come I miss out on all of this? You've missed 47 episodes, but that does not mean that you cannot catch up, because you can visit us at smallbusinessportal.com. Not only will you have access to these videos, but you will also have access to the weekly memos. So we've actually, on Wheels, we've created an entire checklist for you to consider when you're drafting your will. We have looked at the financial solutions for your business. We've gone through in in-depth detail what financial statements you need to have for your business. So much information available to you. Please do not miss out on it. And if you're wondering, for those of you who are in Jamaica and are on another lockdown this weekend, what are you going to do with your time? You're going to binge watch COVIDCASTJA. Thank you, Tamika. Thank you, Renthia. We are so pleased to serve you. We will be back next week at 7:30 p.m. for another episode of COVIDCASTJA, brought to you by the private sector organization of Jamaica with our sponsors that we cannot stop thanking, NCB Group and the JMMB Group. See you again next week. Walk good, stay safe, wear your mask, sanitize. So you have a great idea to start a business, but you don't know where to start. We completely understand. You have a lot of questions and almost no answers. Smallbusinessportal.com is here to help. At smallbusinessportal.com, you gain access to information on loans, grants, and investment opportunities from verified financial institutions. Guess what you also get? Useful business tips, access to training. All these services combine to make your business idea into a reality. Start your journey today at smallbusinessportal.com.